on Friday. We just wanted to make an appearance to let you know that they filed that notice of non-suit and a proposed order.
I think I've already signed that, actually, I believe. Let me see.
Oh, my apologies.
No, I'm not. Yeah, I just signed that. So just so
Okay.
you know, she
Okay.
should be able to get that. I think that's a partial non-suit, right? Or is
Um, it was a non-suit with prejudice.
for the entire case? Let me just look at it. Let me see.
Just of EAN Holdings.
Okay, that's what I meant. It was a partial
My
non.
apologies.
All right. Okay. So anything else for that case today?
No, sir.
All right. You have a great rest of your day and appreciate you showing up.
You too. Thank you.
All right. I think our next hearing is our special appearance. Um, all right. Tony, are you ready?
Yes, Judge.
Let's go on the record on DC 2321453. Uh, Edward Roberson versus Western Carriers, Inc. Counsel, make your appearances.
Good morning, Your Honor. This is Aubrey Boswell. I and Sydney D'Elia are here for the plaintiff, Edward Roberson.
Judge, this is Joe Cox, and along with Ramsey Schultz, we're here for the defendant, Western Carriers.
Okay, let's go ahead and proceed.
All right, Judge, this is Western Carriers special appearance hearing, and I just want to give you just briefly the background facts of this case.
Okay.
Yeah, I can't see you, but yeah, there you are. Okay, so this plaintiff, doctor, he's a medical doctor, I think. I'm not exactly sure, but Dr. Roberson was a Colorado resident at the time that he entered into a contract with Western Carriers. And if you allow me to share my screen, Judge, I will.
Yeah, I'll do that right now. Go ahead.
Okay, so I'll share my screen. Let me go with screen 2. Here is do you see that, Judge? This is the bill of lading that relates to the delivery of this wine that he now claims is missing, okay? You'll see that it was picked up in March, right up here at the top here, in March, for pickup date, March 1 of 2022, okay? 185
Your Honor,
pre-packaged.
if I may, I'm not sure. I'm not able to see what's being shown by defendant's counsel.
I can't either.
Oh, you can't see it? Oh, okay.
No.
Oh, hold on a second. How about now?
Looks like your desktop.
Okay,
there.
well, it's on the other. All right, I got the wrong screen.
Yeah, that's what I see too.
There we go. Okay. How about now?
Yes,
Yeah,
I can see that.
Can you see it now, Judge?
Yes.
Okay, sorry about that, y'all. I had it on the wrong side.
No
Okay,
worries.
so this is the contract. This is the bill of lading with respect to this shipment of 185 total boxes of wine here, 140 on 225, and then another 45 on 3/1, Judge. This is 3/1 of 2022, okay?
Okay.
Then do you see this now? This is their exhibit B. Here's the delivery. 5 pieces, 5 pallets down here, 3/9 of 2022. This was delivered to some address here in Dallas. Keep in mind that plaintiff for this bill of lading, plaintiff was a Colorado resident at the time that this was entered into. You can see it here, Edward Roberson, 211 Madison Street, Denver, Colorado, 80206.
Okay.
He was shipping his wine somewhere down here to Dallas to some sort of wine vault or something like that. Not exactly sure.
Wait, did it get shipped directly from your client to
No.
Dallas or from your client to Denver and then he shipped it to Dallas?
This was picked up by a third party from Mr. from the plaintiff's residence, we believe, and it was taken to a spot for a few days in Denver, and then it was shipped by a third party down here to Dallas. My client does not have carriers here in this area. We don't own the trucks or anything. A third party shipped this for Mr. Robeson, for the plaintiff.
Let me make sure I understand I have the chronology correct.
Okay.
So it was shipped from your client to Denver. Am I understanding that? And
No.
then it was shipped from your client to Carrollton?
No, the plaintiff here, Judge, was shipping his wine from his residence in Denver to a wine vault here in Dallas.
Okay, but initially it was sent from your client to Denver?
No, my client has nothing to do with it. My client picked it up in Denver for the first time.
Okay.
My client's a shipper. My client is actually used a third party to pick up this wine and then deliver it to Dallas. Does that make sense?
No.
The plaintiff already owned this wine and he lived in Denver, Judge, and it was stored in his wine vault in his house or whatever he had in his house.
So your client did not sell it to him?
We did not sell it to him. No, we're just a shipper.
Okay, and you shipped it from Dallas to Denver?
No, Denver to Dallas.
That's right, from Denver to Dallas. I apologize.
Right,
Yeah.
Denver to Dallas. My client doesn't own the truck that shipped it, Judge. We're just got to handle the logistics of it, where it had a third party actually do all this work. My client's employees did not do this work. Okay. So
Okay.
the wine's picked up on 3/1. See this, the last part of the wine was picked up on 3/1. See 140 units over here. It's picked up on 3/1, and then, Judge, it's delivered on 3/9 of 2022. The dates are important for various reasons, but I want to establish that this was in March of 2022 that we were picking up this wine for the plaintiff, and then third party shipping it for him down here to Dallas. Okay. This plaintiff, Judge, this plaintiff did not request any insurance on this. He chose to forego insurance, and we have the emails that relate to that. But be that as it may, he shipped his wine, and then not until June of 2023 did the plaintiff go over and ever check to see if all of his wine made it, supposedly. So well over a year later, Judge, a year and 3 or 4 months, in June of 2023, he finally goes over and looks at this, or I don't know if he'd been there before. He doesn't say that in his petition. But the problem is, Judge, is that his contract here that he signs says this: any and all claims for shortage under paragraph A, B, or C, which is insurance, if he wanted it, he declined the insurance. We have the email that says that. B is another way he gets his own insurance. We don't know if he did. And C is not purchase insurance, which is the situation we're in. Any and all claims for shortage under paragraphs A, B, or C above must be made at the time of delivery while Western's delivery representative is present. Any notations regarding shortage must be A, written on the bill of lading, the delivery document, and B, communicated to Western's customer service representative at the time of delivery via telephone, fax, or email. While the delivery representative is still present, any and all claims for damage under paragraph A, B, or C above must be communicated via email or fax within 2 days of the time of delivery. Any claims not in compliance with the foregoing shall be deemed to have been waived. He doesn't like that clause, but that's what's in this agreement. Furthermore, Judge, in this agreement is this. This agreement down here, right here, this language here, This agreement shall be governed and construed in accordance with the substantive laws of the Commonwealth of Massachusetts, as if this agreement were executed in and fully performed within the Commonwealth of Massachusetts. Venue for any litigation or arbitration between the parties shall be exclusively in Worcester County, Massachusetts, unless otherwise agreed to by the parties in writing. This agreement, together with the shipment's bill of lading, completely express the full agreements of the parties. And Judge, just so you can see, there are the signatures. There's the plaintiff's signature. Here's somebody for Western, for my client right here. Okay. We've established, so those are the background facts, Judge, basically written contract.
Yeah, so let me hear from Mr. Boswell on the point, just that last point. I'm
Sure.
not so concerned about the 2 days because I think they
Okay.
have some merits, but let me hear from Mr. Boswell or his co-counsel on
Sure.
how do you get around this mandatory venue clause?
Very good, Judge. I'll stop sharing my screen, okay?
Okay.
Very
Yes,
good.
Your Honor. Thank you. I appreciate that. And so we're here. This is essentially a game of misdirection by the defendant here. They essentially have 5 different venues that they want to seek to play a shell game with. There at no time are there any parties who have been in Worcester, Massachusetts. The defendant is not there. The plaintiff is not there. The defendant, if you actually look, if I can share my screen on this, Your Honor.
Go ahead. Go ahead.
Okay. Yes, Your Honor. Can you see that?
Yeah.
Okay.
Go ahead.
This is the contract that was entered into between the plaintiff and defendant. And as you'll note here, it in the very opening paragraph, it says the defendant here, Western Carriers, a Delaware corporation, so that's one potential venue, is located in Bergen, New Jersey. That's a second venue. And then it lists plaintiff Edward Roberson, residence at that time, Denver, Colorado. That's a third. And then if you'll look in the next paragraph, this is a shipping agreement to go from Denver, Colorado to Dallas, Texas, Dallas being the fourth venue. And then on top of that, as defendant was referencing in this contract, there is a forum selection clause for Worcester, Massachusetts, a fifth venue in this. This is really a game to try to
Mr. Boswell, I mean, I guess those are all possible venues, but you have a mandatory venue provision. I guess I want to go back to my initial question, which is, how do you get around the mandatory venue provision?
Yes, so we actually brought our case under the Texas Deceptive Trade Practices Act, a Texas statute that we believe the defendant has violated that must be interpreted by a Texas court. And there is a Texas Supreme Court case and a U.S. Supreme Court case that outlines when a forum selection clause can be overridden because the defendant has minimum contacts in the state of the subject state. And we believe that here the defendant has substantial contacts with Texas for multiple reasons, one of which is that this very contract.
So let's go to that Texas Supreme Court case then. I understand. I'm dealing with the first issue to me is, how do you get around the mandatory venue provision? And that's kind of what I want to hear from first. Let's not go to the other issues yet.
Okay. Yes, Your Honor.
So what is this Supreme Court case? Then what does it say?
Yes. So this Supreme Court case is the International Shoe Company versus Washington. This is a 1945 Supreme Court case that says that
I studied that in law school, so let's talk about the Texas Supreme Court case.
Oh, yes, Your Honor. That case is the BMC software case versus Marchand. This is a Texas Supreme Court case of 2002 that says that the Texas long arm statutes can reach out and grab a defendant
Okay,
and bring
does
them
it
to
talk
Texas.
about a mandatory venue provision or mandatory? I understand that before we get to minimum contacts, I want to talk about the mandatory venue provision.
Oh, yes, Your Honor. So this case has been further explored in GJP Inc. versus Gauche in Texas that
How do you spell
outlines, Your Honor.
How do you spell that for the court reporter?
Oh, yes, Your Honor. GJP Inc. versus Gauche, GHOSH.
And that talks about a mandatory venue provision.
It does, yes, Your Honor. This case is specifically about forum selection clauses in Texas.
Go ahead and share screen that case.
Share what on this case, Your Honor?
Share screen the case, please.
Oh, yes, Your Honor.
Or you could have your co-counsel do it, whatever's easier.
Is there a site for it? What is it? 251?
This is an Austin Court of Appeals case, it looks like.
251.
Yes, Your Honor. This is an Austin Court of Appeals case.
Okay, we'll go to the key point that you want me to look at. Where does it go? Does it talk about mandatory venue provisions?
Yes. Put up here.
And I'm familiar with all this stuff. Let's get to the mandatory venue provision.
Okay, I'm looking, Your Honor, for had it pulled up here just a second ago.
Mr. Cox, are you familiar with this case? Does it have anything to do with mandatory venue provisions?
Yes, I know that the BMC case does not, and I don't think this one does either, Judge. I just tried to get through it while he was looking at it, but I couldn't really see. I've never seen this Gauche
Mr. Robertson.
GP versus Inc. Gauche case.
Hi, how are you?
Okay, there's somebody talking. Is it?
It's it's the plaintiff Roberson's talking, Judge. He's on his phone there now. He just muted himself.
No, I just muted him, but.
Oh, you did. Good. Thank you. Okay.
So I will say one of the first cases I handled as a judge was about mandatory venue, and it was between a case involving the Chinese National Oil Company and the Indonesian National Oil Company involving gas leases off the coast of Papua New Guinea. And the Texas Supreme Court said that there was a mandatory venue provision in that, and so that was enforceable. So I really want to get to the issue of the mandatory venue provision. Is there any cases that you've cited, Mr. Boswell, on that topic?
Yes, Your Honor. I'm
Michiana does not relate to a forum selection clause, Judge. That was a guy who bought an RV in Texas from somebody in Michigan. It has nothing, it talks about minimum contacts. It's a minimum contacts case.
Okay.
So this case actually it does relate to a form selection clause, and discusses whether that clause should be upheld.
It says, we
And-
agree with the Court of Appeals that a form selection clause designating Indiana does not necessarily indicate Michiana had no minimum contacts anywhere else. Generally, a form selection clause operates as consent to jurisdiction in one forum, not proof that the Constitution would allow no other. Okay, so this one does seem to at least address it.
So this right here, Your Honor, specifically is where the court's saying in this very second to last sentence, Holton does not assert that the clause itself was fraudulent, he induced and presented no evidence showing why enforcement would be unreasonable or unjust. We believe here that the enforcement of this clause would be unreasonable and unjust, and that the court should not enforce that clause in this contract.
Okay, so what is the standard for unreasonable and unjust? And what evidence have you presented on that topic?
So, to my knowledge, the court has not outlined a standard for unreasonableness and unjustness, but I do have evidence here to present to the court as to those two elements.
Is that attached to your briefing?
Yes, Your Honor, it is attached to my briefing.
Okay, go ahead and share screen that.
Okay. And I realized that one of the attachments, it's actually from the Western Carriers website. It's very condensed on the attachment, and so if I may share an expanded or zoomed in version of their website.
Okay.
Okay. Go ahead and share that. This is an image from Western Carriers website. In their pleading, they make a lot of suggestions about not having any contacts with Texas, that they don't have any business really in Texas. And on their website, they specifically refer to themselves as a Dallas Wine Transportation Company. And then they go on to say, we coordinate it all. We do the storage, we do the transportation. And then they give several examples here of how they do business in Dallas specifically. And so this is directly from their website. It's one of the things that the plaintiff here relied upon whenever he chose this company.
Judge, Judge, wait a minute, I have to object then. If he's going to say his plaintiff relied upon it, he has to show that that was what the website looked like back in March of 2022 or before. That's not the website from 2022. So I have to object to it, Judge, if he's trying to use it to say his client relied on this, because it's just not true.
Well, what I'm saying is that my client relied on representations from the defendant that they do business in Dallas, that they were actually in the midst of I'm going here to a second printout. This is a press release where Vino Vault, you'll see the headline, Vino Vault acquires Western Carriers collector business, now operating in 9 locations across the U.S. This was from June of 2023. The reason Mr. Roberson specifically selected Western Carriers was because they sold him on this idea that they both would store his wine in Dallas in this company called Vino Vault, and that they were undergoing an acquisition of Western carriers, and that everything would tie together. And this specifically shows that they were undergoing that acquisition that later consummated at this time period. And this was specifically why Mr. Roberson selected Western carriers.
Let me ask you kind of a different question. Are there any cases that you have found that have analyzed a forum selection clause and found that it was unenforceable because it was unreasonable or unjust? I assume you're not arguing that it was obtained through fraud, right? Is that correct, Mr. Boswell?
I don't think we're taking that off the table at this point, because
do you have any evidence that it was obtained through fraud?
well, at this point, we are still undergoing discovery, but the notion here is that my client relied on their representations specifically about the business that they do in Dallas. They knew he was in the process of moving to Dallas. That would be his residence.
Did they represent to him that venue would be in Dallas if there was a dispute?
They represented to him that they did significant business in Dallas.
Okay. All right. So I guess kind of I need to know, is there any cases that you found that have interpreted a mandatory venue provision and found that it was unenforceable because it was unreasonable or unjust?
Your Honor, if you'll give me just 1 second.
And your co-counsel here can also assist you if that would be helpful. Do you know of any? Ms. Delia, do you know of any?
No, Your Honor, I do not.
All right. I'll be honest, I don't like this any better than you do. I'm not a big fan of mandatory venue provisions. I do know that I was kind of shocked that I had to handle a case between the Chinese National Oil Company and the Indonesian National Oil Company. Is one of the first cases I ever handled. And my predecessor and I would have done the same thing, said that, hey, Texas has no interest in this. Supreme Court said, nope, you still got to hear the case.
Your Honor, if I may, I believe there is a case that did overturn.
Go ahead and share screen it, please.
Okay.
And this invalidates a forum selection clause.
This case, they discuss forum selection clauses, and they specifically talk about when they can be enforced and when they cannot be enforced.
Okay.
And so.
And was the forum selection clause thrown out in this case, or was it enforced?
No, it was granted, Judge. We conditionally grant the writ of mandamus and direct the trial court to.
So the trial court refused to enforce the forum selection clause and then was reversed?
Yes, it's an AutoNation case. It's been out for.
Mr. Boswell, that's not helpful to your case. All right.
Your Honor, here's the holding. Here's the holding. Right here, it says in the middle of the screen, we held that the enforcement of a forum selection clause is mandatory unless the opposing party clearly shows that enforcement would be unreasonable or unjust, or that the clause is invalid for such reasons as fraud or overreaching. This is a Texas Supreme Court case that says that they're mandatory unless these elements are proven. And we would ask, Your Honor, that we could conduct further discovery before this court makes a decision to enforce this mandatory or this forum selection clause.
I'm going to go back to my initial question. Have you found a single case in Texas, not just Texas Supreme Court, where a forum selection clause was not enforced because it was unreasonable or unjust? Your co-counsel says no. You said this one said that it wasn't enforced, but it was. Is there a single case that you found that it was not enforced? Mr. Boswell.
Your Honor, I don't have a case before me, but I have this Supreme Court case that says that they're mandatory unless these elements are shown.
Okay. All righty. Again, let's go back to my initial speech was I don't like these things. I have a concern about, but I understand the Supreme Court. I've got to follow what the Supreme Court tells me to do. There's many times I don't always agree with it, but it is what it is. The law is what it is. You haven't found a single case anywhere in Texas that has actually not enforced a forum selection clause, and I don't see anything different about this case. So I'm going to go ahead and grant the special appearance. Have you guys submitted a proposed order?
Yes, Judge, we submitted a proposed order when we filed it. Right, Ramsey? Ramsey can answer that. Ramsey, you submitted a proposed order, right?
Yes, the proposed order has been submitted.
What day did you submit it?
I believe it was March 4th, but let me make sure that's correct. Yes, it was March 4th.
Okay, let me. Okay.
You find it, Judge, you need us to resubmit.
Yeah, no, I'm having a problem. No, you guys have done that. She's absolutely correct. It was submitted on March 4th. It's just my Odyssey just went down for me, so I need to see if it. I'm not sure why. Let me reopen it and see if I can get it pulled up. You guys don't need to stay. This is just
Okay.
a computer issue. So,
Thank you.
all right, guys, good argument on both sides. And you guys have a great rest of your day. Okay.
Thank you for your time, Judge. Have a great
Thank
day
you.
yourself. Bye-bye.
Thank you.
Your Honor.
Judge, I placed that order in your queue.
Oh, the order denying the special appearance?
The proposed order for special appearance on
Well, thank you for doing that.
March the 4th.
Okay, thank you. I'm having some problems with Odyssey. I'm not sure why. All right, do we have anybody else here on hearings right now? Mr. Fox, are you here for something? Mr. Fox? Mr. Fox, are you here for something?
He's muted.
Mr. Fox, are you here for something? Okay, I think he disappeared.